Well, hello, everybody, and welcome to the 147th episode of Stories of Service, Ordinary People Who Do Extraordinary Work. And I am the host of Stories of Service, Teresa Carpenter. And today we have Ben Beliles. I should have asked the pronunciation before we started the call, but how are you doing today, Ben?
I'm doing well. Good to be with you, Teresa.
It's good to be with you too. And today we are going to be talking about one of my favorite subjects, which is the law. As you guys know, I've had a number of lawyers on this show, ones who are associated with the military and who can help explain some of the more complex issues, break them down, make it a little more simple for us, and talk more about some of the things that we can do as advocates and as people who want to ensure that people are getting a fair treatment and have a fair process for as they resolve issues. So as I said in the show notes, behind the headlines of those scandalous stories, there's real people whose lives are forever changed by these cases. And I believe that what we see in the news is not the full story. And sometimes it really is slanted to fit a one-sided narrative. So that is why I encourage people on the show, and I bring on experts like Ben here to share these stories when it comes to seeking justice. And today we're going to be talking about how service members have sought accountability. We're going to hear stories behind the story on some of Ben's most compelling cases and his suggestions for reforming the military justice system. Ben is a former Air Force JAG officer and trial lawyer with over 15 years of experience in complex criminal prosecution, civil litigation, defense, appellate work, and internal investigations. He focuses his practice on white-collar crime and complex civil litigation matters and advocates for victims of sexual assault and sexual harassment in the military. Prior to entering private practice, Ben served as senior trial counsel for the Special Victims Unit of the U.S. Air Force at Ramstein Air Base in Germany. As a senior prosecutor for the Air Force's legal offices in Germany, Italy, Portugal, Turkey, and the UK, he first chaired 46 jury trials to date. While serving in that role, Ben was named Special Victims Unit Prosecutor of the Year twice. Before leaving active duty, he served as a federal litigation attorney, defending the agency in employment actions in administrative and federal litigation. And in that role, he was designated the Air Force subject matter expert in sexual harassment-based removals of civilian employees. Notably, and we'll talk about this today, Ben successfully prosecuted Lieutenant Colonel James Wilkerson for sexual assault at Aviano Air Base, Italy. The convening authority, Lieutenant General Craig Franklin, then threw the verdict out, which made the case a lightning rod for change to the UCMJ, and Ben was integrally involved in a systemic revision to provide more robust protections for victims of sexual assault. During the fallout of that case, he served as a media contributor and suffered extensive reprisal for those who opposed the changes to the military handling of sexual assault. He's licensed to practice in Virginia and is permitted to practice in all military courts, many federal courts, and including the Eastern and Western Districts of Virginia, the Fourth Circuit Court of Appeals, the Federal District of Colorado, and the Central District of Illinois. In his free time from his private practice, he is also a part of the Assistant Commonwealth Attorney in Virginia, focusing on prosecuting sex crimes and domestic abuse. Graduated from the University of Virginia School of Law, one of the top 10 law schools in the nation, and in 2006 was commissioned in the Air Force as a second lieutenant after completing the University of Virginia's ROTC program. Welcome again, Ben.
Thank you, Teresa. It's great to be with you.
So first off, I always ask my guests who joined the military, where were you born and raised, and what inspired you to make a life or have your early path within the Air Force?
I was born and raised in Charlottesville, Virginia, where the University of Virginia is, so Central Virginia, a pretty nice place to grow up. I honestly had no plan to be in the military. I had, grandparents who served in the military in World War II, that sort of thing, but didn't grow up in like a family that was, had father, mother, or someone close in the military. But for me, it was actually 9/11. I was in college. I was 19 or 20, and that was pretty big impact on me. And me and my best friend went and joined Air Force RTC program the week after 9/11. So that's how I ended up being redirected into the Department of Defense. That wasn't necessarily planned, but obviously that was kind of what inspired it at the time.
So you went into the Air Force as a JAG?
I did, yeah.
So tell me a little bit about what it was like those early years serving as a JAG in the Air Force. Was it something that you felt prepared for with your schooling, or were you sort of caught off guard because it was so different from what maybe some of the other students were doing at the time? I know you were in the ROTC program, so you probably knew a little bit about what to expect, but I'm curious if it was comparable to anything that you had studied or trained for up to that point?
Yeah, I probably wasn't that well prepared for the, through my training or law school or RTC. I had RTC, I had, some summer camps and that sort of thing. But my first assignment was actually in Guam. So I was at Anderson Air Force Base, Guam. So it was a long way from home, very different, very remote environment. Yeah, I did not, it was definitely a learn on the job sort of situation. I didn't feel like the law school had prepared me for certain things like rules of evidence and how to present a case and that sort of thing, but not how to be a JAG and to deal with the issues that we were dealing with at the time.
What would you say what would you say were some of the notable highlights as a junior JAG officer that you feel shaped where you are today?
I early on I excelled as a litigator in the Air Force, and that wasn't something I really had planned on. I just got a lot of experience in the courtroom early on because we were a small base. I had a lot of responsibilities at a prosecuting in federal court in downtown in Guam, Agana, Guam, and then in the military side. And then I got to be a defense counsel in Guam, or our sole area defense counsel very early on, and kind of got to develop my litigation skills there in the Air Force. And we got to do cases in Japan, Okinawa, Korea, and that sort of thing. So Hawaii. So it was a really good, quick education in the Air Force about litigation.
Mhm.
From that position, I got to transfer to Ramstein Air Base, Germany, where I was the senior trial counsel. Basically, my experience and my performance in the courtroom, and court martials, basically
Mhm.
allowed me to take that position. In that position, I was one of about 15 in the JAG in the Air Force who basically traveled around and prosecuted ultimately mostly sex cases. 2/3, maybe half. Mine was probably more than 3/4 in USAFE. We were prosecuting bases up near Cambridge, RAF Alconbury, Lake and Heath, Milton Hall, Lodges Field, Incirlik Air Base, Turkey, Aviano, of course, Germany as well. So that was kind of what allowed me to take that position early on and start learning how to really prosecute sexual assault cases, especially often in the Air Force. We had in the DoD, often we had, acquaintance rape cases, often, involving drinking and going out or with people you knew, which are more difficult cases to prosecute successfully.
Absolutely, and the people that I've talked to who have done the sexual assault cases, they do say that they're some of the hardest to prove because of a lot of times there's not any uh, real clear proof, and a lot of times the people have to rely on testimony as proof, and then basically assessing if the parties are believable. How do you feel as a lawyer you were able in those, what did you learn? Like, what were some of the things you took away from those cases that really you think made the difference in making sure that the rules of evidence was properly adhered to?
Learned a lot. So I would say that early on, as a senior prosecutor in the Air Force, I mean, we weren't prosecuting sexual assaults very well. This was
Mhm.
2010, 2011. And I learned definitely through losing some cases, unfortunately, some difficult sexual assault cases at RAF Milton Hall and Aviano in Germany. Like I some painful losses that were good tutors for how to. And yes, you bring out a point that a lot, and when it comes to sexual assault cases or sexual harassment cases, most of the evidence, most of the litigation involves what happened between two people, usually two
Right.
people. Obviously, there are exceptions. And often it's there, unless there's some, videotape of what happened. We have to look to other things and we have to rely upon witness testimony and credibility. In the Wilkerson case, after it's thrown out, one of the big talking points for the defense was there was no evidence. There was no evidence. No, there was evidence. The victim in this case testified quite
Testimony is
credibly,
evidence.
and we
Mhm.
corroborated her. We corroborated her story in we built building blocks, essentially, little kind of bricks to support her. Yes, they were not a video. They were not
Right.
a videotape confession of the defendant, but we corroborated her testimony as well as with other people's testimony to build that case against Wilkerson. So it is difficult. It's extremely difficult, but you have to learn how to. I think I learned how to corroborate victims, help them remain consistent. The reality is, highly trained defense lawyers can develop inconsistent statements through in the testimony of people who are telling the truth, for people who aren't not lying.
Right.
That's why good lawyers are paid the big bucks. To develop. And when you have to tell a story over and over again, or write it down multiple times, every single time is a different version. It's impossible for a human to just replicate what they say. So obviously there are going to be inconsistencies, and so as a prosecutor, I learned how to try to ensure that there were the fewest possible inconsistencies up front for communicating expectations with victims up front as to what I expected, which was, yeah, there's maybe some tough things you need to talk about in testimony. Talk to me about them now, and let's make sure we work through them and deal with them. Don't fail to mention these things and leave us in a bind later on, or make yourself look like you were hiding something. Let's deal with it. Let's avoid, an inconsistency or a perceived inconsistency. So I got good at that. And then just advocating for them in their interests. At that point, we didn't have special victims councils. Those were only created after Wilkerson in 2013. That was one of the other. Once Wilkerson was set aside, Article 60 was changed to remove.
Can we just back up just so the audience knows? Can you just give a very brief summary of the Lieutenant Colonel Wilkerson case, just for those people who are listening who might not be familiar?
Absolutely. The Wilkerson case was a general court martial that happened at Aviano Air Base, Italy, which is a fighter base, F-16 fighter base at the time, kind of on the point of the spear in Europe for the Air Force. And so it's mostly, it's obviously caters to the fighter pilots to a great degree. In that case, a fighter pilot who was a lieutenant colonel, Colonel Select, who was the IG actually, he was the inspector general for the base, ironically, sexually assaulted a physician's assistant, a 49-year-old woman who had come there to serve in the DoD on a contract a few months before, didn't really know the DoD, didn't know who Colonel Wilkerson was. He sexually assaulted her without getting into the details of the party. That would be a lot. He sexually assaulted her in his house, actually, his own house. And she reported pretty quickly. And we successfully prosecuted the case. It was high profile because he was a fighter pilot. He was a Colonel Select because he had a sterling career going. That was unusual, obviously, and it was unusual for us to be successful in a prosecution of a litigated court martial. Myself and Colonel Christensen my boss at the time flew out from DC. We prosecuted the case. We won the jury trial. He was sentenced. What made it more memorable, that was significant. I don't think most people expected us to win. He had the whole F-16 community was out to support him with letters from generals, and there was also character letters, which are no longer allowed after that case. Good military character evidence.
Did the victim testify as well?
Yes, she testified. I put her on the stand. Her name was Kim Hanks. Her name's Kim Hanks. And she testified quite credibly. It really had no motive to fabricate this, but yet a lot of pressure was brought to bear on her to try to drop the charges or to show that she was a liar, or crazy, or to imagine this and that sort of thing. So it was a pretty intense court martial itself. But after the court martial, Lieutenant General Craig Franklin, who was then the 3rd Air Force commander sitting at Ramstein, overseeing all the bases and Air Force bases in Europe, somebody who was probably destined to be the chief of staff of the Air Force. I mean, that was kind of the path. He was on the path to replace General Welsh potentially at the time as chief of staff of the Air Force, and beloved. For whatever reason, he got involved in the case and was convinced that this individual that he knew in passing, he was also an F-16 fighter pilot that actually flown a mission in Iraq in 2004. So he was a little conflicted, but there were no rules. Convening authority could do whatever he wanted. At that point, Article 60 of the UCMJ said that a convening authority could set aside a conviction for any reason or none. And that was the way the UCMJ had been since it was, promulgated in the 1950s. So in this case, he was convinced that this guy was a good family man. I'm not sure why, based upon the evidence, but he was a good family man. There's no way he could have possibly sexually assaulted someone. And he, with a few months later in early 2013, threw out the conviction, convinced that this was a travesty of justice, despite 5 Air Force colonels finding him guilty. A jury of his peers. They like to complain that there weren't fighter pilots on the jury, but they're all Air Force, white Air Force male colonels. So they were pretty similar to this man. He certainly got a jury of his peers more than most Americans. So it was thrown out, and at that time, Colonel Christensen and I, there were no counsels for victims. Now we have special legal counsels, VLCs in the Navy. That didn't exist. So we worked with her to essentially get her story out there when this was thrown out. We worked to protect our defenders, Nancy Parrish, and she actually went on the Today Show. Colonel Christensen met with Secretary Hagel about this. There was a Senate Armed Services Committee hearing on March, I want to say 12th, 2013, in which Senator Gillibrand from New York basically grilled the TJAGs as to how did this failure of justice occur. Ultimately, it led within about a month or two, which is really the unusual thing about this, because that change actually happened and happened quite quickly because there was so much groundswell. It was kind of a story that went viral. It was all over, mainstream news sources, New York Times, Washington Post, etc. It led to Article 60 being changed by later that spring. Congress actually by May or June of 2013 had removed that power from committing authorities, so they could no longer set aside a sexual assault conviction. They also created,
Wow.
so that was big, but more importantly, they created victims legal counsel or special victim counsel, that different names in different branches for victims. If you allege that you were sexually assaulted, you get a free legal counsel now. Or there's some other, I forget where it stops. I believe domestic violence as well is covered. But yeah, so that was a pretty extensive new right for victims, even without a conviction or anything. This is initially. And then finally, what happened? The third thing that happened that was significant at the time was the Article 32 process, which is the preliminary hearing process for general court martials in the military, was changed so that victims of sexual assault did not have to testify in it. They would be declared unavailable, and their testimony could be admitted through a written document or a statement or something like that, that was very significant in allowing cases to survive that process. Because when I was early on as a senior trial counsel in Europe in USAFE, prosecuting these cases, we had to put the victims on usually at the Article 32. There wouldn't be a military judge, and it was the Wild West going into their personal background. We were trying to use the rape shield law, which we have, Military Rule of Evidence 412 in the military. But this system, we didn't have judges. We had people who didn't know how to apply it. So it was, we'd have the victim on the stand for hours, sometimes half a day, of being cross-examined
So
by an
painful.
extremely good, military Air Force Senior Defense Counsel about everything. And so cases that were legitimate often just fell by the wayside. People they would feel so battered by the end of that experience, victims they would drop out. So it was very difficult. So that was gone now. There was no requirement for them to testify anymore. Which also made it easier not to have inconsistent statements, because when you get questioned for 3 hours about something, it's
Right,
pretty
you're
hard
going to
not to
slip
be
up a
inconsistent.
detail here
Yeah,
and there.
or you just phrase things differently, and then
Sure.
and a highly attuned lawyer takes advantage of that phrase, because that phrase sounds different than a different characterization of something. So and then finally, actually, there was a fourth thing that came not from Congress, but the military rules of evidence were changed after the Wilkerson trial to remove the right. It's a defense called good military character. It was a defense for all of the 60 years of the UCMJ. Prior to that, a defendant could put on, only in the military, evidence of good military character. This kind of general, he's been a good soldier, he's been a good sailor, whatever,
Yes.
for 20 years. And he would put in either testimony, character testimony, or general or affidavits from people. So in the Wilkerson case, he had 100 affidavits of good military character from all the way up to retired 4 stars and 3 stars, saying, there's no way he could possibly, have done this. And then those would all go before the jury, even though they really weren't relevant. That's more something for sentencing. That's more something to consider. Okay, this person's done a lot of good things in their life. Maybe they should get a lesser sentence. That would certainly be an appropriate place for it to be there. Here in the military, historically, the judge would read an instruction saying that you may acquit the defendant based upon his good military character, and that alone.
Right.
So even regardless of any other evidence, and I can tell you sometimes that would happen.
Yes, I know a friend of mine, and I was gonna ask you what year that went into effect, because a friend of mine had a Marine colonel, and I won't say who, although she tells her story as well, who was that exact policy was used against her, and he was basically allowed to quietly retire because of the fact that his military history and his sustained superior service was used to weigh more than the incident of assault.
Yeah, no, I mean, I believe it changed. I believe it changed in 2014. I think that was the year.
Okay.
Could have been late 2013, but I believe 2014. Could have been 2015, but it was right in there. I want to say
Right
2014.
around that time. Okay.
But yeah, no, obviously, a good military officer, is a very political. The DoD is very political, so a popular military officer would be able to get naturally a lot of good military character affidavits, and typically are a senior enlisted person, because they're just good at networking. They have good relationships with people, and
Of course they do.
most
Yeah.
people don't know what they do in their private life typically.
Nope. No. And that is sometimes the problem. And I was gonna bring up something else too that I saw, and not to use an entertainment case, but I know it's popular culture. A lot of people have heard of it, and I watched it very closely, which was the Johnny Depp Amber Heard trial. And as you watch Amber Heard on the stand, And I came to believe that in that case, of course, there was two people who had done bad things to one another. But I definitely believe that in watching that Amber Heard was the aggressor. However, as you watched her testimony, I firmly believe she believes herself. In other words, I think that even when people are guilty, or when they're falsifying evidence, or sometimes when they're testifying in a way that they're basically lying, sometimes they don't even know they're lying. It's this weird thing where I think people almost brainwash themselves into thinking that they're in the right, even when they're not in the right. And they've convinced themselves that in Amber Heard's case, that she really was as severely abused as she says she was. And so I'm curious from your perspective, because when we say testimony is evidence, have you had witnesses on the stand where you really do believe they believe their own story, even though you know their story is not credible?
I've certainly experienced that in different forms, not necessarily just victims, but
Right.
witnesses. There's
Mhm.
certainly I'm not necessarily sure what psychological
No,
condition.
I don't know it either, but I'm wondering, as a lawyer,
Yeah,
you've gotta know when that's happening, because you really cannot argue with someone who believes their own story or believes their own spin, if that makes sense.
absolutely. There are definitely people. There are definitely people, and I've unfortunately had to interact with who start to realize the reality, even if they're impeached by hard data or something. They
Yes,
believe, or they've
they
led
do.
themselves to believe their story.
They
They're
truly
convinced
believe it.
that they're in the right, or they're telling the truth, and it's
Mhm.
not.
Even if it's told
Sometimes they
about
sometimes
false
they
lie.
forget it's not the truth, or they
Right,
never knew. I'm not sure.
right.
There is that is a reality. I think when it comes to supporting witnesses' testimony, that's why it's important to be able to corroborate with important data points
Mm,
a testimony. Um, to show that that there's an indicia of reliability here. It checks out because there are text messages, there are timestamps, there it's corroborated by other data points. And to be fair, a lot of times these sexual assault cases come down to a credibility determination between two people sometimes as to who's now obviously the defendant's not required to take the stand necessarily, but often their story is coming in through their testimony or something else, something they've said or an interrogation or something. But yeah, it definitely comes down to credibility. So how do we help corroborate people who are telling the truth?
and that's where you have to just find, like you said, those other pieces of evidence that can support the argument, one way or the other. So after this case, and the headlines from it and all these things, did you want to continue in the Air Force, or were you at a crossroads at that point where you said, "Okay, I think I'm going to go down this other road into private practice"? What was the path like for you after that point?
So I actually initially, I unfortunately had about a 3.5 year commitment left at that point.
Mhm.
When the Wilkerson case came down, and because I was not very happy about it, to be honest. I was pretty upset about it and made my feelings known. It was for me, for Colonel Christensen, for the other people involved in the case. It really was an outrage. It was a very clear case in which somebody was extremely guilty and was now being set free. And we who were trying to protect the system, trying to put the best foot forward, do the best job we could within the system that existed. It was extremely disappointing. So for me, I actually tried to resign from the Air Force at that point. I submitted a resignation letter and tried to, and
Mhm.
it was kind of the rift time period. It was the cutting time period. And so I thought I would be able to be allowed out. So I actually got a job, or I applied for, and I was accepted as to be the executive director of Protect Our Defenders, which Colonel Christensen
Mm,
later went to work for, and when he retired
right.
in 2015, was going to be allowed out. The Air Force had my couple of chains of command had all supported my voluntary resignation, early, because of we were cutting people. So it was like, okay, this person wants to get out.
Sure. Sure.
Well, when they found out that I was going to be the executive director of Pod, about 4 days later, my separation was remarkably denied up at AFPC, personnel people, even though everybody in the chain had supported it, and it could have been granted. So I spent 3.5 more years in the Air Force after that. So
Gotcha, gotcha.
yeah,
But at that point, you knew, like, the writing was on the wall that you wanted to get out and go into private practice, correct? For
yeah.
those last 3 years. Okay.
I mean, if I had many lives to live, I would definitely stay in the military. I had the best job in the world. I prosecuted sexual assault cases all over Europe
Mhm.
as the lead person on the investigations in their courtroom. To be honest, I told my chain of command I'd be happy to stay a major. I promoted a major in that position and do this for the rest of my life because I was doing it as well as you can do it. I knew that because of my
Mhm.
ratings, my results, just the outcome.
Right.
Frankly, from just putting in the time, from also
Right.
losing some of these cases and just learning how to win those types of difficult adult acquaintance rape cases or sex assault cases. And the problem was the Air Force, DOD is just set in its ways that it doesn't matter that I was doing that at such a high level. It's no, you're going to go be a deputy staff judge advocate because you have to develop your career, down in somewhere else. So I was kind of eventually after I actually stayed in the position for 4 years, which is kind of long. But I was moved on to do other things, other litigation, but had to
Hmm.
leave doing what I was doing very well.
And is that where you ended up ending your career, ending your military career was out of that assignment?
So after my senior trial counsel position at Ramsden, I had an assignment in DC at that Andrews Air Force Base for about two and
I
a half
see.
years, and I separated out of that when my commitment was up. Yeah.
And then once your commitment was up, did you make the move back to Virginia at that point?
Well, I had since I was stationed at Andrews when I PCS back from Ramstein, I was in Northern Virginia, so I was already in Virginia by then. But yeah, I
Okay,
kind of at that point I kind of transitioned into more private practice and more Virginia focused practice.
I see. And so at that point, did you want to say, okay, I'm only going to I represent military people as a defense attorney, or I'm sorry, or as a private attorney, or did you want to start taking on some of these other cases that I see you're now involved with today?
It was not so clear exactly, but initially I represented mostly military clients, and then I started getting involved later on after a couple of years in more plaintiff work for sexual harassment cases. I was involved with. I'm a member of the National Women's Law Center Gender Equity Network, and so I get cases referrals, and so I've actually had done a number of lawsuits against school districts in Virginia, federal contracting companies, a number of those in DC. Because you see a lot lack of oversight a lot in those venues and those arenas, because it's kind of a wild west and a lot of money coming in federal contracts. So I started doing those things. I do represent a lot of DoD members today who are going through. They're in different situations in the military involving. So I help kind of maneuver work wherever they are in that
Right.
administrative investigation, EO investigation, whatever it is. So I do a lot of that, and then I still do. I do criminal defense, federal criminal defense, mostly white collar work, and then I also obviously prosecute on the state level.
Gotcha. So I want to now transition a little bit to some of the things that you've seen. You've been on both sides now of the military justice system as a practicing attorney within the Air Force, and then now in your private world. And what would you say are some of the consistent patterns that you see from the military justice system that would benefit from a bit of reform? Like, what would you say are some of the main things that, as case after case after case, you're sort of seeing certain patterns?
I do think some very positive change has been made. To be clear,
Yeah, that definitely. That
yeah,
was one thing I would want to definitely highlight and take away from this conversation is that one of the things we as advocates need to always do is celebrate how far we've come, not just all the
exactly.
work that needs to be done. And when I as we go through this, it's really clear to me that there been a lot of, like you said, a lot of good changes that have been made.
A lot has changed. Certainly, very different than 10 or 15 years ago. We certainly are more focused on victims, protecting victims. The resources are there now that weren't there at all. So it is a different world. The way we talk, or the education within the DoD is different and it's far better. However, and I do think, by the way, the new stand up, it's going to kind of happening right now. The new stand up of the Office of Special Trial Counsel is significant. Will have positive. Colonel Christensen was largely behind that, along with Senator Gillibrand, and pushing that. I think that is trending the right direction. Finally, it's always been this whole commander controlled UCMJ process has always been a problem. There's also Ryan Swayze's pushing to try to get the IG process taken out of the chain of command as well and into more of an independent process. And I think that trend is important and will benefit in the long run. But yeah, certainly we're still not doing a very good job of it. Sadly, we're
No.
not. The Air Force is actually probably the worst at prosecuting sexual assaults right now. The numbers are horrendous. The DoD is still doing a poor job. So there have been a lot of changes made. One of the biggest problems, I think, is that a lot of the changes are mostly on paper and not really implementation. Certainly in a lot of my clients who are in investigative stages, they see there's a lot of rights now for victims. There's a lot of things they're supposed to be getting, updates, check-ins, all sorts of things, but they're not happening.
Right.
They're just not happening. And you can complain, you can throw a fit, that's about all you can do. Because obviously you're just a needle in a haystack. There's thousands of investigations going on. It's a
Thousands of
mess.
cases. Yeah.
Exactly. So, and they can't all be on the front page. They can't all be getting media attention all the time. So it's a battle of implementation to a great degree. And I think that's a great failure on the part of the DoD still to actually make these things actually happen. I think the DoD's failed to really. Someone like me, I would have been happy to specialize in this case or in this arena, in this type of case, and do this for the rest of my career. I would have been happy to do that, but the DoD had at that time. We've gotten a little bit better. We're starting to specialize.
Mhm.
We're starting to specialize in litigators and senior trial counsels and stuff long term, but we really haven't done that long term. We insist on moving people around and engaging in general practice, and even if people are the best at what they do, we say it doesn't matter. It doesn't matter if that person can win
Mhm.
cases. We're going to replace them with an inexperienced person and let them figure it out for a year or two. And in the meantime, we lose another 5 or 10 sexual assault cases, and then we wonder why people are upset. So I think, those are two things. I definitely think you have to have a process that's outside the chain of command. When you look at the IG investigations, just the way it's done, I have no faith in their independence or their ability to actually conduct investigations.
But they're not trained. I mean, they're not resourced and they're not trained. And
Yeah.
there's been studies that have proven that everyone from the investigating officer to sometimes the people at NCIS, and not to say that everybody at the investigative services aren't great people and some aren't doing a wonderful job, but there's definitely evidence there that they don't receive the training or they're not staffed to handle the kinds of cases. I had Tim Parlatore on my show, and that was really eye-opening about the Eddie Gallagher case and some of the tactics that were used during that case and some of the things that happened during the course of Tim's experience working with the legal system. And he echoes everything that you're saying. And that's what's so interesting. It doesn't matter what lawyer I talk to, they say the same things.
Yeah, I think anyone who has the experience and sees and deals with what we deal with, I think would come if they're if they're right-minded, if they have any common sense, they would come to the same conclusions. I don't think it's hard to see.
Mhm. I think that one of the things that makes it so difficult for the military to do the things that I think need to be done too is that they're to 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 really clean up the investigative system. It would require budgeting. It would require a lot of resources to be put in this direction. And I just don't know where and how they would bring about those resources. I mean, but it gives me hope though when you say that the resources were now we have a special, victims council. We have, like you say, an Office of Special Prosecutions. So the resources can be made available, is what I'm hearing.
I think that that's been made available after a decade of a lot of advocacy, a lot of a lot of attention being brought to the issue. So it's slow, but yeah, it has been shown that we can make changes that bring those resources, move Congress to bring those resources to the right place. The
Right.
problem, I think, one thought I was going to say about the IG investigative process, I think part of the problem also is that today, in most branches, in my experience, the IG system is really a way for the command to really kind of identify who are the problem children in their mind who are actually making the complaints, identify them and reprise against them. I think it's exactly the opposite of what it's supposed to be. It's really, oh, here are our problems, and how can we get rid of these people or deal with
There.
them? That's really more of what it's. I'm not saying there aren't some good IGs out there and some people who are doing honest investigative work and making changes, but for the most part, it's really more of just a complaint process. Identify them, let the command know, oh, these people have initiated these investigations, and let the DoD to go to work, and there will be reprisal.
What really astounds me too is I wonder, and I've thought about this for a while, how much of a difference would it make if there were some sort of a conflict mediation process. Because what I find when I have on the victims of some of these cases, or some people who feel they've been wronged through these investigations, is that there was always at the beginning of these conflicts, there were little signs within the environment, within the culture, that if they had been identified early on, and if they had been handled and talked through and dealt with in a transparent way, they would have never gotten to the point where someone's writing a million memorandums for the record on every little thing. And there becomes this like kind of almost like a battle, like a fight between two parties where each side is just lodging different actions. But
Mhm.
if you go back to the beginning of these conflicts, there were things that I feel like could have been resolved early on. And I just wonder, is do you think there's any possibility that they could somehow, I don't know, bring in some sort of mediators or bring in organizational psychologists to work on the culture side?
Yeah, obviously, I haven't seen that done, and I haven't seen that really proposed in any significant way. I definitely think on your kind of your lower, I think you're speaking to a lot of issues in that end up maybe in the EEOC process, often leading to allegations of racial or
Mhm.
sex discrimination or other things like that. That often I do think you're right. They often sometimes begin perhaps on a lower level, and they're more personality conflicts or people with if there was someone there to mediate, educate, perhaps they wouldn't escalate. So I don't think it would be the solution for the cases that end up in as sexual assaults. But
No, no,
yes, your
not
kind
in
of
a
your lower
sexual
level stuff. But the issue is, how is it mandatory? Is it binding? Is the mediator someone who, their recommendations are required to be implemented if the
That's
parties
true.
submit
That's
to it?
true.
Does the command have to submit to it? So there's a lot of things that would have to be worked out, or no one would do it. So there'd have to be a way to essentially have some incentive to force people into that process. But if so, yeah, I think it could help. We're definitely in a time period where we have just, an abundance of complaints and extremely litigious society, so there's no question in my mind that if we could, at the lowest level, your lower level, low hanging fruit,
Mhm.
a mediator could definitely be useful to help resolve some of those lower level situations.
Because I feel like on either side right now, people aren't happy. In other words, there's the people who feel that they've been a victim of a sexual harassment or some sort of a wrongdoing. A lot of times it's even just workplace bullying. So there's those people that have been victimized. And then on the other side, there are people who feel that the system has been weaponized against them, and that basically they can't properly lead or they can't properly hold people accountable because they feel that if they do, they know that a complaint of retaliation or this and that. So I
Yeah.
feel like on either side right now, the system isn't really set up to bring about justice or to hold people to make it so that it's fair. And I just wonder moving forward, other than being able to somehow change the culture, uh, and really bring about better, more ethical leaders. There really isn't a ready-made solution that's going to be able to handle some of these cases. I do think the idea of bringing these cases outside of the chain of command is a great first step because you have an unbiased third party, hopefully, that
Hope.
can look at this and see it with fresh eyes and not be attached to the outcome as much.
Yeah, absolutely. I do think we're in a very toxic time period in which, yeah, you're right. How do you change a culture in which it is like people are at extreme odds, and it's just people are at loggerheads to a great extent. So
Mhm.
that is difficult. I'm not exactly sure what the solution is,
Right.
but certainly having processes in which they at least are as impartial and fair as we possibly can make them for other
Yep.
people to see, and they address them, and they're investigated in a timely manner. And things don't, they're not, swept under the rug for 2 years before they're investigated. I think that's the best we can do to at least try to restore faith in the system, in the process. And I think we need to restore faith in the system so people can buy in and stop, you know, fragmenting at the edges. I do think we're kind of at a point where no one has a lot of faith in the system. And so everyone's out there, people are going to act in their self-interest. They have to protect their interests. They have to protect their career. So they're going to do whatever it is that they think is in the best interest of their career, typically.
And what I really want to see going forward too is I want to see our flag community or our general officer community. I want to see them talk about these issues. I feel like there seems to be such a I was talking to a career coach about this earlier today about how people mistake my advocacy for a lack of loyalty. And I think that there's this misconception and this perception that if you're speaking about these issues and these things that we want to change, that means you're not loyal to the organization. And I understand where that comes from. It's a
Yeah.
very traditional and very, I would say, cultural mindset. But I would respect our leaders more if they would address these issues and say, yes, we do have these problems. This could be contributing to our retention and our recruiting problems. The fact that people don't have faith in the idea that they'll be their problems will be properly adjudicated. And so I think that is probably maybe the first step too, is that we would like to see our leaders talk about this. I mean, I would think, Ben, is that something you'd like for to see more of, or to see of at all?
Leaders in the DoD.
Yes, like addressing the fact that there are issues within the military justice system.
Yeah, absolutely. I do think we often see almost a willful blindness from leadership in the DoD. They want to try to say, "Hey, we know we have addressed it. We are addressing it. Don't worry. There's nothing to see here. Let's move on to something else." And clearly, the problem isn't fixed. So it's not like we can just move on to something else. So I do want to see that. I've seen really good leadership at the general officer level on issues. In the Wilkerson case, the wing commander at Aviano, General Zobris, was a 1-star at the time. Went on to be promoted to major general. Handled it remarkably well, and just was on top of it. Was concerned for the victim's safety and healthcare and well-being at all times, even though there was no process at the time to do that. On the other hand, I've seen General Franklin, who was concerned about the accused and only the accused, and getting him restored to duties, and to command, and didn't even ask about who was going to inform the victim that he'd set aside the conviction. That I always remember that. But yeah, so I would like to see it dealt with. I think we need a conversation on this to a certain degree. So I think if we're not having that conversation led by, from the top in the DoD, I don't think that conversation is really going to happen in a healthy way.
Neither do I. And I'm very selective about the people that I have on that have experiences with this. So people who are personally sharing their story, because I know what a sensitive issue this is. And I also know that as a podcaster, I'm not a litigator. I'm not trying the case. I just want to hear people's stories. But I would want nothing more than to have somebody within the flag or the general officer community come on here. I've tried actually to get a lawyer from the Navy JAG side on, and after several emails, I gave up because I just didn't get the sense that they really wanted to discuss the processes, and they may not be empowered to do so either. I'm not sure, and maybe I'm not the venue that they would like to talk about those issues on. But I think that the first step to healing is to just have those conversations and to be able to say that, yes, there is a problem. It astounds me how much Ryan and Francesca and the folks at Walk the Talk Foundation have raised on this issue, especially on the investigative, the IG side. And I just I don't sense that there's any response on the part of DoD, even to acknowledge that there is this problem. And so going forward, I think that's something that I know many of us advocates would like to see. And I bet on your own experiences with these people who have been victimized by this process, I'm sure that's something they'd like to see as well.
Absolutely. I don't think the DoD usually it changes slowly. I mean, I think that's definitely clear. So I mean, we shouldn't be surprised that it's going to take a while sometimes to make positive change, and hopefully we don't grow weary in trying to do that, or and give up. But I do think unfortunately the DoD usually only changes when something really significant happens, like when it came to the court martial system, it was the Wilkerson case. It got enough coverage, enough senators and Congress people were outraged and that sort of thing. Just to almost be embarrassed. So I mean, the DoD is very afraid of the media. Mainly, they usually don't interact with them that well, and usually are run from them. But usually it takes something traumatic almost for there really to be real change. I don't want that to happen to for the
Right.
IG process to be overhauled. It shouldn't take that, but historically, usually that's what it takes, something really significant for there to be change. Otherwise, the status quo is usually what the powers that be like to leave in place.
I agree. Well, I think we're kind of getting towards the end of the call, but I do want to also touch upon just hiring a lawyer and deciding that you need a lawyer versus if you represent yourself, how much can you do on your own? Because a lot of people who have had something happen, they want to hire a lawyer, but they're very weary to do it because they might not be able to afford it, or they might think they can do a lot of it themselves. Like, where's that line in your mind of
Yeah.
what people can research on their own and do by themselves? Because some people, I mean, like my husband, my God, that guy could research things nonstop. I mean, it's almost like a rabbit hole with him. You have to stop him from just going so deep into things. And then some of the people don't want to do any of the work or any of the research or don't understand it or can't
Yeah.
do it.
Yeah.
How do you think you can judge that?
Well, I can tell you it's if you're referring to like these administrative processes, IG complaints, EO investigations, part of the problem is that they last forever. So part of the problem, so it's when you have a situation that's going on for 2-3 years, which is part of the problem, is that these cases aren't being investigated in a timely fashion. They're being
Mhm.
they're always delayed. They're never timely, pretty
Right.
much currently. So they take forever. So to have a lawyer with you at all times it's a big undertaking for that lawyer. So it is difficult. I would say some people are better equipped to do things on their own than others. Certainly, their natural inclinations, knowledge, experience.
Mhm.
I would, I think there are a lot of people out there like me who try to help as much as we can, and where we can't help, or we try to let the person handle on their own so that they're not paying for attorneys or when they don't have to. I think most attorneys in my kind of field, and kind of not there's a lot of people doing what I do, but are kind of cognizant of that. People can't pay for an attorney 24/7 for 2 or 3 years of an
No.
administrative investigation. That's just not
Right.
it's not realistic in this day and age. So I'm not sure exactly where the line is, but I would certainly encourage people to go to organizations, advocacy organizations, like if they're a victim, like Protect Our Defenders, get all their resources. If they're more in
Or
the
walk the talk.
walk the
Right.
talk, I was going to mention, if they're more in the IG, not
Hmm.
necessarily quite as, even though they do also work with sexual harassment survivors, but also, just more generally the IG investigative process, that sort of thing, other toxic situations in the office place in the DoD. Take advantage of all those resources, consult with lawyers for free, see what they can offer. And work with a lawyer, maybe not all the time, but work with them where you need a lawyer, where you feel like you're in the blind. Don't just walk blind into things. Make sure you talk to somebody and make sure, because unfortunately some of these investigative processes, if you don't file it within the correct number of days, if you don't, there are all these different little things that if you don't go through the right wickets, your complaint gets dropped, dismissed with prejudice, and you can't bring it back, and so it's gone just because of a small technicality. So it is hard to find that line, but I definitely encourage people to definitely get free consultations. I give free consults at most lawyers in this. Well, at least you can get some information there. See if you need a lawyer, or
Hmm.
see if this is the right time. Maybe it's a good conversation to have, and maybe if certain circumstances arise, maybe at that point, I need to call that lawyer back and hire that lawyer for X reason. That's how I would handle it. It's hard, you have to feel it out to a certain degree. It's different depending on the person and the situation.
Yep, absolutely. I mean, I've talked to people who've done both. Talked to people who've gone the lawyer route. I've talked to people who've represented themselves. I've talked to people that had a lawyer, then ran out of money and started representing themselves for the rest of the case. So it is all an individual decision on the part of the person. But yeah, just don't walk into it blind. Use the resources. I even encourage people to sometimes, I encourage one person to start a Facebook group. And if and just reach out to other people who've had similar cases.
Mhm.
Sometimes just doing some research with other people and learning what their experiences were, I think can be very helpful. But if people want to get a hold of you, Ben, how's the best place to reach you?
Feel free to reach out to me on my website, benwinsagain.com, or my email address, bbeliles at benwinsagain.com. So yeah, I'd love to hear from anybody on this and talk to them if I could.
Awesome. This is a great domain name, by the way. I saw
Thank you.
that and I was like,
It's a little corny, but it's catchy.
no, it's catchy and it's yeah, benwinsagain.com. You really can't get any simpler than that. And that's sometimes
Exactly.
what you need. So, well, Ben, I'll meet you backstage to say goodbye real quick, but I'm going to go full screen. But I thank you so much for coming onto the call and informing all of us a little bit more about this system, what we can do, and what we can do better, and also how far we've come.
Thank you, Teresa. Great speaking with you. Hope you have a great day.
All right. Awesome. All right, everybody. I just want to thank you all for joining another episode. We had 2 episodes this week, so I know that was a lot, but really great to get some of these episodes in. As I've said before, on August 1st, I will be going on a 2-month hiatus after that August 1st podcast so that I can prepare for the move stateside to Mississippi. So we will do season 3. We'll start in October at the Military Influencer Conference. So I'll be doing some broadcasts from there. And I'm really looking forward to that. And I'm looking forward to having some really great guests. I'm building the lineup now for this October. But as I always say, when we end these calls, take care of yourself, take care of each other, and have a wonderful day. Bye-bye now.